Okay, welcome to the NSPS Town Hall. My name is Tim Birch, I'm the Executive Director, and today we're here to talk about and share with you the model law, NCEES Model Law, and our speaker today is Gary Kent, who's been at the forefront of this for, I think, what did we decide, Gary? It's been at least 18 months. I mean, it's been a while.
Yeah,
so,
it's been probably pushing 2 years by now.
Yep, 2 years, and really it's been a great conversation, and Gary will get into that. So we appreciate everybody coming up, being able to show up today and listen to this. I want to set a few little ground rules here, simply because this is really for information, and if we try to talk about this back and forth, we could be here for literally days. So what we've set up for the procedure here is, if your state, if your jurisdiction has questions, comments, suggestions on what needs to be changed, put them in writing, email them to the NSPS office. You can send them to my attention or info@nsps.us.com. Either way, the committee, which consists of Gary as the chair, Linda Foster, NSPS Vice President, Davey Edwards, NSPS President-elect, and Amanda Allred, NSPS immediate past president. They're going to be getting together after we get all of these the comments and conversations from you and the states. They're going to be due by the end of January 31st. And so as soon as we get all of those, this little ad hoc committee will put them together and go to town back on this, and hopefully we come up with a good resolution we can pass as the NSPS board for recommendations to go to the NCEES board and their committees for consideration. So without further ado, I present Mr. Gary Kent. He nearly needs no introduction, but we do need to allow him some time to kind of sift through this, because this is a good document. It really truly is, but he needs to be able to explain it, and this is a great forum to do that. So with that, Gary, please take it away.
Okay, thank you, Tim. I thought I would give a little background on this first. A number of years ago, I was invited to sit as kind of an ad hoc member of a ERISA committee called the PAC Committee, Policy Advisory Committee. I wasn't representing NSPS. They just reached out to me because I've been involved with GIS. I've spoken on GIS actually at some ERISA conferences, at ESRI conferences. So somehow they found me. It may have been because Brent Jones was also involved, and Brent's been works at ESRI, and I've known him for, gosh, 20 years probably. But in any event, I got involved in that group. Well, about maybe 2 years ago, a year and a half, probably pushing 2 years, that committee spun off out of an informal group of people to look at the model law for surveyors from the perspective of GIS. And I was immediately asked to sit in on that. That group, I've got the names here. That informal group was comprised of Bruce Jaffe, who's a ERISA member, Ed Wells, who is also a ERISA member, Ryan Hunsiker, who is a ERISA member but as a professional surveyor, Brent Jones, who is a ERISA member and works for ESRI and is also a professional surveyor, Linda Foster, of course, our NSPS Vice President, Trip Corbin, who is a ERISA member who I've known for a number of years, and who else? Linda, Trip, Brent, Ryan, Hunsiker, Ed, and Bruce. I think that's all of us. So there were actually 1, 2, 3, 4 surveyors involved in this effort. In any event, we started looking at the model law. The initial impetus was that there's been a lot of stuff happen over the last 20 years. The model law, with respect to the relationship with GIS, goes back really to 1997-ish, I think, and then I think NCEES, which actually they refer to as NCEES, adopted it in the early 2000s, I believe. And this was an effort that was initiated by ASPRS, American Society for Photogrammetry and Remote Sensing. Jim Plasker was their executive director at the time. And they have a lot of people involved in GIS too. So there was some concern there, and there was a large, I don't say large, there was a very focused effort to address GIS with respect to the practice of surveying at that time. Well, that's been over 20 years ago, and there has a lot of things have happened, especially in technology and practice. All sorts of things have happened. And there's been litigation, there's been all kinds of confusion. And so this group spun out and decided, let's look at this. So we worked on it for well over a year and felt like we were approaching something that looked like a pretty good document. And then the conversation turned to, well, how do we get this in front of NCEES? And I'm a board member in Indiana. I've been on our board now for 20 years, actually, next month. And I said, well, logically, it would go through either a state delegation or one of the NCEES zones as kind of getting it into the queue in the overall organization. The conversation then turned to, and I think it was my suggestion, was, this is going to be far more well received if it comes from or with the endorsement of surveyors rather than just GIS folks. So then the conversation was, well, how do we do that? And I think I had suggested, well, let's get a hold of Tim Birch. He's executive director of NSPS. Now, understand at this point in time, the proposal coming from ERISA, it was the intent of them to get it approved by the ERISA board and take it to NCEES regardless. But the thought was, it'd be better if we had endorsement or concurrence from NSPS. So that's how Tim, we invited Tim in. He was not part of the negotiations, if you could even call it that, but it really wasn't a negotiation. This was a very focused effort on the part of a bunch of very professional people who were interested in solving some problems by addressing the model law. So once Tim was invited in, and that was really to help figure out how do we get this to NSPS and hope that they will endorse it. So that all happened, and that went then to the fall meeting, which was, I think, in October. Unfortunately, I couldn't be there. I think it was the first fall meeting I've missed since 1983. I think there could have been a lot of confusion prevented had I been there, but it was impossible for me to be there. I had a pre-existing conflict. But in any event, that's how that came to be. And at that point in time, the thought was, ERISA wants to, or this group wanted to get this to NCEES and hope that NSPS would endorse it. So that's how it was presented. I think the thought has changed in that group to let's get comments and suggestions from the surveyors. It's not unlikely at all, and perhaps it's likely that there will be some very good suggestions that can be incorporated in either on their own or to address some concerns. So that's kind of where we're at now. The ERISA work group is sitting tight, waiting for NSPS for this town hall. What will happen then, and I think people have been notified on this, that if your state has input, whether you concur, maybe you just want to say we're good with it, you have concerns, you have suggestions, those go to NSPS, to Tim, by January 31st. And we needed that time because the committee, which Tim mentioned, is myself and Davey Edwards and Amanda Allred and Linda Foster, we need time to absorb all of these and incorporate what seems appropriate and proper into the proposal, get it back to the ERISA group so we can hopefully come to some concurrence on that, and in plenty of time for the April NSPS, the spring meetings. And we want to make sure there's time for all this stuff to happen. So that's why January 31st. I understand that means that some states will not have had your annual conference, although my thought is this really is probably not a topic that you throw out at an annual conference because you'll spend 2 hours kicking it around. I think it probably makes more sense to do what NSPS has done, which is assign a relatively small group of people to absorb this and understand it and then make a recommendation. But states will do what you feel is appropriate. So that's the background. What I would like to do now is walk through this because there are some things in here that are a little confusing. They tie back, they tie forward, and I want to make sure everybody understands the changes that are being proposed at this point, understanding they're not been in front of NCEES formally. I think they have been viewed by some of the leadership at NCEES who is quite interested in seeing this brought to them. I'm not sure what that means, but I think there is some interest there. So I got the model law up here. What I've done is in red, I've got the additions, and in purple, I've got the deletions. So I just want to walk through this and hope we can all understand what we're doing here. So the first change comes under the definition of practice of surveying. And I do need to preface this, that in part of the conversation, I had myself some concerns about the model law. And I knew that many of you, if not most of you, know who Jeff Lucas is, an attorney and surveyor, and writes columns, writes books, and makes presentations. I knew Jeff had some concerns about the model law. In fact, he had conveyed them to NCEES some time back. And so I got a hold of him. I thought, well, as long as we are making, suggesting changes, let's fold in these changes also. And I'll discern between what are those and what are the GIS related things. So the first thing we've got under the practice of surveying, it used to say using such sciences as mathematics, geodesy, and photogrammetry. I feel, and there are some states that have in their definition of surveying that invoke aspects of the law, relevant aspects of the law. I think this is critical because that's what boundaries are about, right? Boundaries are not about math. They're not about the coordinates. They're about applying law to evidence. And so I felt, and I know Jeff feels, it's critical that we include reference to the law in the practice of surveying. So our change here, but using such sciences, but not limited to mathematics, geodesy, photogrammetry, and relevant aspects of the law, including both. Now, the work group said, let's emphasize both here because this is part of the confusion. What NCEES, by the way, does with all of this, they are going to do, right? But we want to make our suggestions. So we said, let's emphasize this is two things. One, making of geometric measurements and gathering related information pertaining to the physical or legal aspect or legal features of the earth, improvements on the earth, space above, on, below, there, and providing, utilizing, or developing the same into, and it used to say survey products. And that's really, we don't really produce survey products. What we do are produce survey deliverables, right? And there's a reason that we're going to discern, because later on we have a definitions for surveying deliverables. And there's a reason that we've done this. So we said developing the same into surveying deliverables. This what I've highlighted here, we struck, but this comes back in later. Developing the same into surveying deliverables, the purpose of which is to establish a legal basis for the reported locations, shapes, positions, and sizes. Now, this is perhaps, well, it is one of the most significant suggestions here. We all are licensed, and that produces or creates essentially a legal basis for what we do. Right? And so what we're trying to do is focus on what we do and the deliverables, which have a purpose of establishing a legal basis for location, shapes, positions, sizes. This is, I think this is one of the main things is that is an issue between surveying and GIS is the purpose for which things are being created. And the reason this needs to be addressed is because if you don't have this, then there becomes confusion. Well, I'm out gathering locations on signs to put in a GIS so that the county can manage their infrastructure. Am I practicing surveying? And I would venture to go out on a limb and say, not for that purpose, because it doesn't have a purpose that has a legal connotation to it. So that's the first thing here.
Hey, Gary.
Yes, please.
Sorry to interrupt you for a second. Can you widen out the document just a little bit, make it a little bit bigger? That's perfect. Thank you. Thank you.
Okay. All right. The second thing, and this part relates to conversations that concerns I've had and conversations with Jeff Lucas. And this is in most state definitions of surveying, this wording of locating, relocating, establishing, reestablishing, or retracing property lines or boundaries. Those words are pretty generic. They're kind of not very specific. And they're actually the cause for some confusion as to what does it mean to reestablish a property line. These aren't words that we normally use in the practice of surveying. What we're talking about here is doing boundary surveying. And there are two types of boundary surveys. There's either an original survey or there's a retracement survey. So our suggestion is let's get rid of these confusing non-specific words and get down to what it is we're talking about, which is performing an original or retracement survey. And then later we're going to define these, by the way. So performing an original or retracement survey of any tract of land, road, right-of-way, or easement. No change made. Then Romanesque 4 here is doing subdivision plats, and then Romanesque 5. This is a change related to GIS also. Right? It's trying to create some specificity here, locating or laying out alignments, positions, or elevations. It used to say for the construction of fixed works, but actually just as important, if not more important, is for the design and construction of fixed works. So that actually is not, that's not really related to GIS. That's just a fact that we should be including design in this definition. But then this part becomes critical. Again, for what purpose? Right? If I'm going to locate some feature, to what end, right? Well, with sufficient accuracy and precision to be relied upon for the provision of architectural and engineering services related to those fixed works. That's what we do. Right? So what we're trying to do is separate this issue of, well, I'm just out there locating these signs, not because somebody's going to design something, not because they're going to build something, but because we're just trying to manage things, as an example. So I think this improves on this, what was really a very concise statement that is extremely broad And it narrows it down to something that's more meaningful and I think more appropriate to the practice of surveying. So that's that change there. Item 8 is one that Jeff had suggested, and this is if we are going to be practicing surveying for the purpose of being an expert witness, and the elucidation of questions is basically a legal reference before courts of law and equity, right? Performing forensic surveys in order to use those as an expert witness or as evidence in court. So that's an addition there, which doesn't have anything to do with GIS. Then we get down here to C, right? And you can't really look at this in isolation either. So we're gonna revisit this down further in the definition. But this is a new suggestion, and this relates to, again, trying to draw a more definitive line, a more meaningful line between what is surveying and what is not surveying. This is the proposal. Unlicensed persons, right? Persons who are not licensed as surveyors, who hold basically a GISP certification, and some people on this call probably do. A Geographic Information System professional. There is a GIS Certification Institute that has a pretty rigorous set of requirements to become a GISP, or a substantially similar certification approved by the board. This would be by your state board. May provide the services and products described in 4A1 and 4A2. We'll go back and look at those. And in 4A7 as it applies to 4A1 and 4A2, provided such services and products include, number one, disclaimers clearly indicating, one, they are not intended to be used as a surveying deliverable, right? So we're tying back to this idea of what are we trying to represent this information as? Are we representing it as a survey deliverable? Well, if we're not, then we're going to say that. Not suitable for legal or authoritative cadastral purposes, which is pretty similar to the phraseology that's in the disclaimers when you go to your county GIS, and on the splash page, you'll have a disclaimer that says something along those lines. And number 3, getting again to the purpose, cannot be presumed to have sufficient accuracy and precision to be relied upon for provision of architectural and engineering services related to the fixed work. So the impetus or the emphasis here is on the purpose for which this is being put. Okay. Number 2, metadata must be included. So this is easy to do on a hard copy. If it's digital format, metadata must be there. It's easily accessible, readable by users, clearly affixed to printed copies. Should include the method of compilation, geographic reference frame, coordinate, linear data sources, creation dates, a whole bunch of information there that is required if this information is not intended to be used for surveying purposes. Now, we mentioned 4A1, 4A Romanesque 1, 2, and 7. Let's look at 7 first. Romanesque 7 is creating, preparing, or modifying electronic, computerized, or other data relative to the performance of all of these activities up here, right? So we said, well, we need to include that, but only as it applies to 4A1 and 4A2. 4A1 is determining by measurement the configuration or contour of the Earth's surface. 2, determining by performing geodetic surveys the size, shape of the Earth or the position of any point on the Earth. This stuff is done by GIS professionals all the time, right? There are, and yet I don't think anybody confuses this as a surveying deliverable. So we're actually kind of improving on what's going on out there by requiring that, no, you're going to have to make sure that that's clear, right? So that's all that. And I know there is a lot of stuff wrapped up in there, and we can't probably sit here and dwell on it, but I would look very carefully at that. I know there have been comments about, well, disclaimers are useless. Well, you know, the fact is this stuff is going on, right? And it's not going on behind our backs. We all know stuff that's going on that falls in the GIS realm, and yet technically it's the practice of surveying. So let's do a better job discerning what people are doing out there when we all can agree it's not the practice of surveying. D, now this is one that the ERISA work group is a little ambivalent about this right now, and we may end up talking to ASPRS about this, but this is actually similar to what we did in Indiana when we rewrote our definition a few years ago. This again is just discerning, other than the handful of states that address photogrammetric mapping, the rest of the states just turn a blind eye to the fact that creating a photogrammetric map is in fact practicing surveying. Well, other than the handful of states that address this, either by licensing photogrammetrists as surveyors and they can only practice in that, or having a separate license, all the rest of the states just kind of pretend like this doesn't go on. And our thought is, let's acknowledge the fact that this goes on and account for it. And so this is not dissimilar from the previous one, but basically saying that photogrammetrists can do what they do, assuming they are a certified photogrammetrist. So that's all that is. And as I say, the work group is a little ambivalent about whether to have that in there or not. We'll see, but we're certainly curious what other people think. All right, that's the main part. Now we get down to some definitions which are important. There is a definition of authoritative, and this came in, I think, with the joint effort in the late 1990s and early 2000s. And again, the work group feels like, let's focus on this idea of to use the term of product, what is the purpose to which this work is being done, right? Because we use the term authoritative later on. The term authoritative, as used in this act, I'll explain the rules here in a second, shall mean being presented as legally reliant. All right, so we're going back to our license. That if it's authoritative, that means that somebody can rely on it, and I am legally responsible for it. Trustworthy and competent when used to describe surveying deliverables. So again, as we did earlier, we struck all this big list, and we're going to include those later on. Let's cut to the chase here. We're talking about instruments of service. Basically, is what we produce as professional surveyors. Technically we don't produce products. People don't hire us to produce a plat of survey. They hire us to do a survey, and the plat of survey is the instrument of service that we deliver to them. So again, we're going to come back to this term authoritative. Here's where, in fact, I'll leave both these on here. Surveying deliverables. What is a survey deliverable? Well, it's an authoritative, there's the term, authoritative map, meaning it's legally reliant, trustworthy and competent when intended to be used as a survey deliverable, right? Graphics, data, construct database, just said data, plans, reports, descriptions, applications, products, or other electronic or printed products, right? We can't say deliver. I mean, we're talking about what is a surveying deliverable, and what that is, in fact, is a product, right? Resulting from the practice of surveying as defined in section 4B, which is the entire definition up there at the top. And going back to the issue of purpose, and fit for the intended use of the surveying service provided. So again, we're focusing on trying to create this division or this bright line between surveying and GIS based on to what purpose is this being put. That's the reason for that wording. Now here's where we define original survey and retracement survey, since we invoke those terms up there instead of locate, relocate, establish, reestablish, retrace. We said we're doing either an original survey or retracement survey. Right? An original survey is performing a boundary survey for purposes of locating on the ground and describing the location of an interest in real property that has not been previously described in a document or documents conveying an interest in that real property. So this is the cutout or the new right-of-way going across someone's property, or the 3 acres being cut out of 10 acres, right? We do that survey for 2 purposes. One is to locate the lines and corners that the client wants to describe so they can sell it, and the other is to describe that area. The term includes subdivision of a section or portions of a section of land under common ownership in the United States Public Land Survey where no subdivision has been previously conducted on the ground. So I think that probably is pretty self-explanatory, but that's original survey. A retracement survey, as used in this act, I mean performing a boundary survey of real property that has been previously described in a document or documents conveying interest in that property by applying the appropriate boundary law principles governed by the set of facts and evidence found in the course of performing the survey. Right? So in a retracement, we know if there was an original survey, what's the appropriate boundary law principle? Following the footsteps. If there wasn't an original survey, then we know we've got the rules of construction. We know how to parse out the controlling calls versus the informative calls in a description. It's all kind of stuff that's wrapped up in this reference to the appropriate boundary law principles. The term includes retracing the lines and corners of a previous original survey, and that's just to clarify and draw the connection between original survey and retracement survey. So that defines those terms that we substituted up top in place of establish, reestablish, locate, relocate, all those things. Now, next is the model rule. Now, I want to clarify this. This is currently in the model rule. So NCEES has a model law, and the idea behind the model law is if your state is looking to modernize their definition of surveying or change it, whatever, that NCEES has a model up there that you could reference, right? That you could use. Many states would have little tweaks they have to do. Some states like Indiana, surveyors can actually practice a little bit of engineering, so we had to address that. But it puts a model out there to start with. Now, in the late 90s and early 2000s, this was the main part. I'm going to pay just here for a second. We're going to visit this. This was the main part that clarifies the division between surveying and GIS. And the recommendation of that group was that this should be in the model law. Well, NCEES decided not to put it in the model law. They put it in model rules. The idea being, well, a board or the legislature will adopt the model law, or whatever your vision of the model law is, and then the board would adopt rules to go along with that. The problem is that boards don't adopt this set of rules, and so the benefit of this whole effort to try and discern between surveying and GIS is lost unless you adopt these model rules, of which hardly any states have done. So our suggestion is let's make this part of the model law, which was the original proposal back in the late 90s and early 2000s. So what we got then is this would be, and the numbering, they would do what numbering, how they do this, but the intent is this would become part of the model law. and it discerns very clearly between, right? So activities included within the practice of surveying, and this is why this is so important to have this in the model law, because if we go back up here and we talk about, I'm sorry to flip around, but here somebody might say, well, I don't understand, or this isn't clear, or what's part, what's 4A, what is that all? How does that all fit together? Well, this makes it much more clear. It says, okay, along with all that, let's be specific. This is the practice of surveying, right? Creation of maps, let's see, representing, and there's the word, authoritative locations for boundaries, location of fixed works or topography. Right? Authoritative, the purpose to which it's doing, legally reliant, that sort of thing. Original data acquisition or the resolution of conflicts between multiple data sources when used for the authoritative location of features, right? Certification of positional accuracy, practice of surveying, adjustment or authoritative interpretation of raw survey data, GIS-based parcel or cadastral mapping used for authoritative boundary definition purposes, right? Now I know that in New Jersey, tax mapping has to be under the responsible charge of a professional surveyor. It's the only state that I'm aware of that does that. But this is just, and perhaps their GIS represents boundaries in there with some more authority than what most are. And we know that most GISs are not representing, in fact, probably none of them try to represent authoritative boundary locations, but this makes it very clear, right? If you are doing a GIS and you are representing boundaries as authoritative, that's a practice of surveying. Authoritative interpretation of maps, deeds, or other land title documents to resolve conflicting data elements. That's the practice of surveying. Acquisition of field data required to authoritatively position fixed works or cadastral data related to or relative to geodetic control. Practice of surveying. Analysis, adjustment, or transformation of cadastral data with respect to the geodetic control layer within a GIS, resulting in the affirmation of positional accuracy. That's the practice of surveying, right? So hopefully you can see that there is, it's tremendously important that this be part of the model law, not hanging out there as a model rule that states will just perhaps ignore, which is what most have done. Next, we get to activities excluded from the practice of surveying. And notice that we really haven't made any change here other than this reference here, which is other than provided in 4BC, which was the exception that we wrote up there earlier. We haven't really changed this, but I want to spend a minute on it to emphasize how, because most of you probably haven't even seen these model rules. They're not in most state laws. And to emphasize how important it is that they become part of the model law to help provide that clarity that we need. So activities excluded from the practice of surveying. Right? A distinction must be made in the use of electronic systems between making or documenting original measurements and the creation of surveying deliverables. And this isn't something we changed, right? This is still reference to surveying deliverables, which is why we kind of use that same reference up in the model law, versus copying interpretational representation of those measurements in electronic system, in a GIS. Right? Further, a distinction must be made according to the intent, use, or purpose of the measurements derived from electronic systems to determine an authoritative location versus the use of those measurements as a reference for planning, infrastructure management, and general information. The following items are not part of the practice of surveying. Creation of general maps, right, prepared by private firms for motorists, boaters, aviators, pedestrians. Publication of a gazetteer or atlas as an educational tool, prepared by educational institutions for use in a curriculum, produced by electronic or print media as an illustrative guide to a geographic location, prepared by laypersons for conversational or illustrative purposes, including advertising material and user guide. I would hope nobody disagrees that a general map does not fall in the practice of surveying. And yet, if this isn't included in the model law and it's not adopted as part of a model rule, you can have disputes over this issue. Number two, now we did make some change here, right? The transcription, it used to say the transcription of previously geo-referenced data. Like, you know, that's probably not the right wording. It said the incorporation of previously produced survey data and or geo-referenced data into a GIS or LIS by manual electronic means and the maintenance thereof, provided that the incorporated data are not clearly intended to indicate, and there's that word again, the authoritative location of property boundaries, shape or contour of the earth, or fixed works. Incorporated data must include appropriate metadata describing at a minimum that it cannot be used as a survey deliverable. But the fact is that under this general scenario, it shouldn't be confused with a survey deliverable, but we add this to make sure that that there's a statement or something on there to make that patently clear. Item 3, again, just change transcription to incorporation. Added down here that the we've got maintenance provided the data are clearly not intended to authoritatively represent boundaries as they were surveyed. The problem here is if somebody creates a GIS and they show boundaries in there, well, somebody may have a problem with that, or there may be some confusion in the law over is that allowed or not. Well, unless it's authoritatively representing boundaries as they were surveyed on the ground, you're trying to represent that in a GIS, then that's not the practice of surveying. And what this would presumably allow is for a GIS, a jurisdiction to incorporate survey data into their GIS, right? And that goes on. That goes on today. So this makes sure that simply doing that is not practicing surveying, because even if you show boundaries in a GIS, they are by definition not authoritative. Right? I mean, the law says a boundary is on the ground. Right? And then we've got the rest of this: preparation of a document by a federal agency that does not define real property boundaries, incorporation or use of documents or databases, again, prepared by a federal agency, census, demographic, quads, inventory maps or databases created by any organization of physical features, facilities, infrastructures that are wholly contained within properties that they have rights to or for which they have management responsibility. Right? Distribution outside the organization must contain the appropriate metadata. If an organization wants to do whatever they want on their own property and manage their stuff and distribute that internally, fine. If they put it outside their organization, there needs to be disclaimers on it. Maps and databases depicting the distribution of natural resources or phenomena by foresters, geologists, soil science historians, all these others. Maps and geo-referenced databases depicting physical features and events prepared by a government agency where access to that is restricted by statute, including law enforcement agencies. So this is pretty specific stuff, and in discerning this stuff is not practicing surveying, and this stuff is. So hopefully you can see why we think it's very important, and probably why the original group that created this document back in the late 90s and early 2000s, why they felt like this needed to be part of the model law. And I don't know the history behind it, but for whatever reason, NCEES at the time decided not to make it model law. They put it in the model rules I think to the detriment of the relationship between surveying and GIS. I think we can go a long ways to kind of smoothing that and preventing problems, preventing confusion, probably even preventing unnecessary litigation by incorporating this into the model law. So that's what I've got, and I know it's a lot. I may try to put together some FAQs, or I would say if you all are not clear on something I said, want to rephrased or need to have it revisited, send a note to Tim, and he'll forward it to me, and then I can respond. Maybe we can put together a series of a set of FAQs if there are concerns or confusion over something that I said. We can address that quickly so that when you are having your conversations in your states that you'll have that information also. Tim?
Coming back on, yes, very good, Gary. Yeah, we've got a few questions out there. I've interacted with them to say make sure we get these documented and thrown to me. My email and the info email is in the chat if you have any questions on what that actually is. I guess one quick question I want to throw out there that was asked. I think this is just more of a clarification. We're mostly talking about the interaction with ERISA and GIS. What about the term LIS? Do you think that needs to be defined anywhere, or is it just a generalization that goes along with the connotation of the term GIS?
Yeah, that's just as an aside, and we weren't going to get into a lot of detail here, but I think early on in the world of GIS, we discerned, we said GIS or LIS, Land Information Systems. I think for the most part, the term LIS is pretty much gone. Nobody uses it. So I've even wondered myself, even before this question came along, is it necessary to incorporate that acronym LIS at all? And maybe it's not. And if it is, we really haven't. I don't think we've defined GIS in here either. Maybe we should do that.
True. Okay, very good. All right. Well, that'll pretty much. I think, Gary, you've covered it quite extensively. Hopefully that gives everybody a little better idea of what we're dealing with here, what we're talking about. Let's also keep in mind that, we can get as thorough and as detailed as we want to be for ourselves. But this is going, no matter what gets approved and endorsed to send on to NCEES, they're going to take it and put it into their into their committees, their review, and shape it however they want to. So I think it's very prudent of us to go through this very diligently. But once it's out of our hands, who knows what we'll end up getting from them. So appreciate you doing this, Gary. For all of those who have attended, and we do have them logged in here, we will get you those certificates out for an hour worth of PDHs because, to be honest with you, I think this is probably more worthwhile than some of the other continuing education stuff we get into at times. It's very upfront in what we're dealing with these days. So, Gary, thank you very much. With that, we'll get it wrapped up. And everybody, have a happy holiday, Merry Christmas, and a Happy New Year. Thanks.
Yeah. Thank you all.